So good morning, Angela. Angela, good morning. Let the record reflect that Angela waves. Monday, and I don't know why, Angela, but somehow I got a day ahead. Sydney, how did I do that? You're preacher. So therefore today we're going to talk about the SEC Act of 1933. That was the year that Keith Harrison started working at Anderson. Wednesday we will not have class, so Angela, make a note of that. Friday we'll talk about the SEC Act of 1934. The next week, on Monday, we'll talk about accountants' legal liability, and we'll begin by talking about the legal liability under the SEC rules. And then we'll talk about the common law liability and the liability to third parties and to clients and Sarbanes-Oxley and Dodd-Frank and all those things that can get us in trouble. So, no class on Wednesday because somehow I got a day ahead. So I don't know how that happened. How did that happen, David?
It happened to me too in computer apps.
Let the record reflect, Angela, that a veteran who's been teaching for 30 years is a day ahead, and David, who's been teaching for 4 weeks, is also a day ahead. So I don't know what that means. Well, let the record reflect. Question number 1. Cody and Tellini, under the Federal Insurance Contribution Act, which of the following acts will cause the employer to be liable? Well, let me ask you this question. Katie, is it important, you're the employer, is it important that you provide Social Security numbers to the IRS? Is that important? They want to know that. Tellini, is it important that you make timely payments? How often do you have to make payments? Somebody know? Depends on the size of the payroll. If it's a small payroll, you can buy it quarterly. If it's a larger payroll, you will have to do it bi-weekly. So the answer to the first one is yes. The answer to the second one is yes. Therefore, Katie, the answer to the question is A. Tellini, you're good. Social Security payments may include all the above, except, now Candace, I don't particularly like this question, because in my mind, Social Security and Medicare are separate. However, Medicare is administered by the Social Security Administration, while Brandon Medicaid is administered by the states. It's a federal program administered by the states, and so the one that is different, Candace, is D, as in David. Brandon, you're good.
Yep.
Social Security payments may be obtained by Kobe, a qualifying individual who are also receiving benefits from private pension plan. Kobe, is Social Security needs-based? No. So will Bill Gates collect Social Security? So therefore, if you have a private pension plan, you can collect under Social Security. And if you have a private, but if you don't, you can also collect. Hey, maybe right, I don't know. Sydney, qualifying individuals and families only upon such individuals' disability or retirement. As a general rule, Cindy, anytime you see the word only or never or always, you have to be suspicious. So let me think about this. Cindy, when can I collect, I have to be either disabled or retired or age 62. If I'm age 62 and working as a janitor, and if I'm below a certain income level, even if I'm not retired, can I still collect? So B is wrong. And the tip-off, Kobe, was that B had the word only in it. C, children of deceased worker who's entitled to benefits until such children reach age 25. That's incorrect, Cindy, because it's 18. And only those individuals make payments while employed. Well, let me think about that. Cindy, the 5-year-old whose parent dies has never made a payment, and the non-working spouse has never made a payment. Therefore, D is wrong. Therefore, by the process of elimination, Kobe, the answer is A. Sydney, you agree? 4, which of the following claims are generally covered under workers' compensation? Judy, both of my grandfathers were coal miners, and both of my grandfathers died of lung cancer, and one of them was a smoker. So, but the fact that he was a smoker and a coal miner, did that aggravate a pre-existing condition? And was it also, Greg, an occupational disease? Therefore, the answer is yes, yes. The answer is A. Greg, you agree? Alex and Michael were injured in the course of employment while operating a forklift. Will you be able to collect workers' compensation? Yes, because you get injured on the job. Michael, can you also sue the employer for negligence? No, because the deal is you're guaranteed payment, even if it's your fault, no matter whose fault it is, but you'll borrow from an action. So therefore, the answer is yes, no. Michael, the answer is B. Alex, you agree? Yes. Under COBRA, which sounds like a snake to me, when the employee voluntarily resigns from a job, the former employee's group health insurance coverage that was in effect during the period of employment with the company, A, automatically ceases. Well, Kelsey, that's wrong. Because the whole point is to continue insurance. B, Taylor, automatically ceases for the spouse, but continues for the former employee for an 18-month period at the former employer's expense. Well, I think, Taylor, that's wrong for 2 reasons. You give me one, I'll give you the other.
It wouldn't automatically cease for
It
any
will
spouse.
cease with the spouse, and it's at the employee's expense, not the employer. Now, Kelsey, C may be retained by the former employee, but is terminated for the spouse. Well, that's wrong, because Taylor just told us it was wrong. Or Taylor may be retained for the former employer and spouse at the former employee's expense for at least 18 months, and that is correct. So Kelsey, the answer is D. Under provisions of the Americans with Disability Act of 1990, in which of the following areas is a disabled person protected from discrimination? Angie, what's a public accommodation?
I would say like wheelchair ramps, so like things that get into buildings.
Yes, that's an accommodation. So therefore, I have to make an accommodation for a person with a handicap. But BG, what's a public accommodation? A hotel. So therefore, I cannot be, if I'm disabled, AJ, I cannot be discriminated in public transportation, nor can I be discriminated by a hotel or a restaurant or anything that provides accommodations to the public. Therefore, BG, yes, yes, the answer is A. AJ, you agree? Question number 8. On the provisions, which of the following statements is correct regarding the scope provisions of the Occupational Health and Safety Act? So, whose is this one? Megan and I? Okay, I. OSHA requires employers to provide employees a workplace free from risk. David, is that even possible? So coal mining, even though it's safer than it was when my grandfathers worked there, it's still a risky business. So A is wrong. B, provide an employer from discharging an employee for revealing OSHA violations. I would think, Megan, there should be some whistleblowing provisions in the law. But David, OSHA may inspect the workplace at any time regardless of employer objection. I don't really need permission, Megan. OSHA does not need permission to inspect, but they can come at any time. They have to give notice. I think C is wrong. OSHA preempts state regulations of workplace safety. David, can we have state regulation on top of the federal regulation as long as they don't contradict? So therefore, could the state provide for more safety?
Yes.
So therefore D is wrong. Therefore, Megan, the answer is B. The whistleblowing provisions. David, you agree? So, and I made some changes to this morning, so you want me to follow those. Federal security laws are designed to protect investors from deceptive, unfair, manipulative practices in buying and selling securities. Securities are instruments such as corporate stock or limited partnership interests, that's somewhat surprising, that evidence ownership or debt. The Securities Act of 1934 created the SEC, independent federal regulatory agency that administers federal securities law. David, when I think of the SEC, what comes to mind? I'm thinking back to January. I'm thinking back in January when the most storied program in college football history, the University of Alabama, should have been playing for their fourth national championship within the last 6 years, but they lost in the Sugar Bowl to a Big Ten team, Ohio State. And I'm thinking, Kobe, that one of the most storied basketball teams in college basketball history, Kentucky, was working on a perfect season, and then they lost to another Big Ten team, Wisconsin. So when I think of SEC, David and Kobe, I think of Southeastern Conference. Let the record reflect, Angela, that was an attempt at a joke that failed. You still have to try. SEC stands for, David,
Securities Exchange.
or Southeastern Conference. And the Southeastern Conference was around before the SEC was, so I think, of course, what I don't understand, Kobe, is why Missouri is a member and why they're in the Eastern Division. I also don't understand why the Big Ten has, what, 14 teams, and the Big 12 has 10. Another attempt at humor. SEC basic functions. To interpret federal securities law, investigate security law violations, issue new rules and amend existing rules, oversee the inspection of security firms, broker investment advisors, and rating agencies. Candace, in other words, to provide protection to the investing public. Oversee private regulatory organizations in the securities accounting auditing field, coordinate U.S. securities regulation with federal, state, and foreign authorities. Securities Act of 1933 regulates solicitation, buying, selling securities, stocks, and bonds. But I guess, David, the first thing we have to do is define what a security is. Security is preferred in common stock, treasury stocks, bonds, debenture, and stock warrants. I'll buy that. But it also, Candace, involves stock options, puts, calls, and other types of privilege on the security, on the right to purchase security or a group of securities in National Securities Exchange. David, it also includes notes, instruments, or other evidence of indebtedness, including certificates of interest and profit sharing agreement and certificates of deposits. An fractional undivided interest in oil and gas or other mineral rights. Candace, investment contracts including interest in limited partnerships and other investment schemes. I'm exhausted after reading this long definition of security. Megan, is this a broad definition? Michael, is this a broad definition? Michael, is this a broader definition than what you might have thought? Let me skip the what is a security, come back to it. See the Howey test in the case on point on 42.1, 42.1 on page 117. Alex, tell me what is a security? And you can do that by just reading the list on page 817. Notice, Linda, from time to time, it's useful to have students do something in addition to simply read notes. Alex, one is there's an investment component.
And a common enterprise.
Two is that it's a common enterprise.
Right.
Three, there's a profit expectation. So Alex, if I invest if you and I going together to create a not-for-profit, then that would not be regulated by the SEC because we don't have a profit expectation. And four, if its management is other. By other, Alex, what do I mean? So you and I invest, you and I would not manage the company. So our contribution is our money.
Right.
And then, case in point 42.1, Alex, tell me about that.
So Alpha Telecom was a payphone system business. They guaranteed buyers 14% annual return, but they were operating in a net loss, and the SEC brought a case against them saying they violated the Act of 1933, and the court said the payphone company was a security because it involved an investment contract.
So therefore, they're saying that we're not security.
Right.
The SEC is saying they are security, and Candace, let me think about that. If it is a security, that means the SEC has jurisdiction. And you'd think that the SEC would want jurisdiction. So therefore, the SEC is always going to have a broad definition of what a security is. And tell me again, so in this case, the court ruled that it was a security, therefore the SEC had jurisdiction, but tell me exactly what they were doing.
The company guaranteed buyers of the systems 14% annual return, but they were operating at a net loss and continually borrowing funds to pay investors the fixed rate of return it promised.
Candace, that sounds like a Ponzi scheme to me, where you are continuing to get new investors, and you pay all old investors with the profits, with the proceeds of the new investors. And does it meet all these tests? It's an investment with a guaranteed rate of return. Candace, that should worry you, shouldn't it? A guaranteed rate of return. It's a common enterprise. There was a profit expectation, and the investors were not the ones running it. So again, Megan, is that a broad definition of security? I think so. In fact, I think Alex had such a broad definition of security that the promoters of this plan probably were surprised that the SEC had come in. So Candace and Katie, tell me something that is not a security.
I guess like an investment in, like someone's personal investment in like a sole proprietorship because that they are the management.
Okay, so, and there's no evidence of ownership, so sole proprietorship. Katie?
Would like a retirement plan.
Retirement plan? Of course, the retirement plan is going to be invested in securities. So, Candace, what about simple commercial paper? Do you remember commercial paper?
Mm-hmm.
Very good. Angela, you remember commercial paper? Angela says yes, so she's nodding her head no. So see the Howey test in case in point on page 817. We just did that. Registration statement. Unless exempt, an offering must be registered before offered to the public. Issuing corporation must file registration statement and prospectus with the SEC. Candace, what is a prospectus? And that's different from the registration statement. David will give you all the details of what has to be in the registration statement. And David, as you read through the details, you could summarize what's in the registration statement by saying a lot. So what's the perspectives? And also, David, when you think about audited financial statements, the management letter is not subject to the audit unless they say something that's wildly untrue. And often, Candace, when an investor looks at a financial statement, they'll go straight to the management letter. And the management letter basically gives a rosy future, a rosy description of what's going to happen, the good that's going to happen to us in the future. And that is primarily an enticement to either invest, to continue with the investment, or to invest or to continue with the investment. So to its perspective, simply, Candace, is an advertisement. Simply is, you should invest in our company because this and this and this and this. So there's a perspective, and I think one of the reasons, David, why the typical investment in an audited financial statements goes straight to the management letter is because that's written in English. It's written, Kelsey, from the standpoint that it has lots of color and lots of graphs and a lot of pretty pictures and so it's more, AJ, more appealing. Well, this stuff, I think, AJ, is kind of would be a good thing to do if you were having difficulty sleeping at night. So the perspective, Candace, is a very glossy colored sales pitch. So you gotta have a perspective. And why, David, does the SEC want to see that? To make sure that you don't make claims that you can't. For example, Alex, to guarantee a 14% rate of return, which nobody can do. Okay. So here's what has to be in the registration statement. And David, you summarized this earlier for me. It's a, you want to play this tape back? It's a lot. The security is being offered for sale, and David, you might want to think about, a couple of weeks ago, we talked about getting the corporate charter. A lot of this information is the same information we use to get the corporate charter. Now we're providing more information for the SEC to give us permission to offer the stock to the public. Securities being offered for sale, including their relationship to the registrar's other capital securities. Corporation's properties and business, including financial statements certified by a CPA. The management of the corporation, including all benefits and any interest of the directors or officers, any material transactions of the corporation must be disclosed. So sending all the interconnecting relationships. How the corporation intends to use the proceeds of the sale, any pending lawsuits or special risk factors. And then, during the waiting period, securities can be offered but not sold. All issuers can do is distribute a tombstone ad. Candace, that's a very interesting term. What's a tombstone?
In general?
Well, a tombstone, Sydney, is when someone, like when Keith Harrison finally keeps a bucket, we'll bury him and put up a tombstone. And so that suggests, Sydney, it's very colorful language, Sydney, to suggest that it's something of temporary existence. Therefore, we can put up a tombstone in and a free riding perspective, and then once we're approved, all we're doing so far, Candace, is we're soliciting interest in the stock. We can't issue the stock in the waiting period. SEC must approve it, and then magic happens when the SEC approves it. Then we can issue the stock. But David, the SEC continues to monitor the process. So, Sydney, the objective is to protect investors throughout the whole process. Well-known seasoned issuers, a WSI, a well-known seasoned issuers, who've issued $1 billion in securities during the last 3 years, or have have 700 million outstanding stock in public hands can file a registration statement the same day they announce. So, why, David? So General Electric doesn't have to jump through the same hoops that a new entity does because they have a track record. That doesn't mean, Sydney, that the SEC doesn't regulate. This means that they don't have as many hoops to jump through. Securities Act of 1933 makes it unlawful for any person directly or indirectly to make use of any means or instruments of interstate commerce or the mails. Why this particular language? Kayla, go back with me to legal environment. And remember that Congress, according to the Constitution, has limited the power. And one of the powers they have is the power to regulate interstate commerce. And therefore, Kayla, if interstate commerce was not involved, then Congress could not do this. So Craig, that language is necessary to be able to give Congress the authority to do this. And then Kayla, what's the thing about the mails? Well, the mails are operated by the federal government also. So therefore, Cindy, the question is, does the Congress have the power, and does the SEC have the power to do this? And the answer is yes, as long as we have interstate commerce or the mail involved. Registration, sell, carry, transmit for the purpose of sale any security unless a registration statement is in effect as to that security. Prospective, carry or transmit for the purpose of sale any security unless such security is accompanied or preceded by prospective that meets the requirements of the Act. Cannot engage in fraud. Okay, I probably should make that bigger font. The following are not covered from the SEC Act of 33, and there's no registration required. Governmental units, Alex not-for-profit securities, intrastate, and then Cindy, if we're issuing stock and the firm is incorporated in Missouri and we will only be selling stock to Missouri residents, then the SEC has no authority. But Talini, that's probably, what's the disadvantage of that? Does that limit my growth if I can only sell to Missouri residents? Insurance products and no sale transactions in security exchanged by the issuer with a 3 with its existing security exclusively or no commissions paid. Tell me what's an example. Sydney, how about a stock dividend? Following securities are exempt from coverage. Short-term paper, commercial paper, which is covered by Uniform Commercial Code and thus not the SEC. Small issues, Regulation A, if the securities are less than 5 million, they're covered by Regulation A, which requires an offering circular, not a prospective. Kelsey, why, and Brandon, what's the difference? Kelsey, why?
They're smaller and they probably don't have as many investors to have need the perspective.
Good answer, and also, Kelsey, we don't want to place as high of a burden on somebody offering $4 million and somebody offering $200 million. And then, what's the difference, Brandon, when an offering circular and perspective?
Isn't it just like a more simplified version?
Good answer. It's a more simplified version. So it doesn't have to cross as many I's or dot as many T's. Court control is the most common example of reorganization under the Bankruptcy Code. This is controlled by the Bankruptcy Court and not the Southeastern Conference. Regulation D offerings. Rule 504 of Regulation D, up to $1 million during a 12-month period, up to $5 million doing I'm hesitating because I think that's wrong. I think Rule 505 Kayla, remind me to come back to this question on Friday. What is the difference? Under 504, you can do up to $1 million. Under 505, you can do up to $5 million to accredited and both non-accredited investors. And so, Michael, what's accredited to investor? An accredited investor would be something such as a bank, or Katie, a pension fund, or an insurance company. And Katie, what's unique about a bank, a pension plan, and insurance company? Should they have more knowledge than Susie on the street?
Yeah.
And so the Rule 506 is unlimited if no general solicitation and notice is provided to the SEC, and you can't have more than 35 unaccredited investors. So Katie, as long as I'm only issuing my stock to knowledgeable investors, and one assumes that these are knowledgeable, then, and I can only have 35 of them, then I have no limit on what I can issue, and I don't have to go through SEC. But it strikes me, Kelsey, that I could avoid these rules simply by issuing it to accredited persons, and then having the accredited persons turn around and sell to the general public. So in other words, what I could do is sort of sending a bait and switch, where I would say, okay, I'll sell it to the accredited, I don't want to bother with the SEC. So I'll sell it to the accredited investor with the understanding, Jody, that the accredited investor will turn around and within a short period of time sell it to people on the street. Which, Kelsey, seems like a neat way to get around this. And Kelsey, would you think that if you and I could come up with this, would you think the SEC would come up with a rule to prevent this? And that is Rule 144. Generally, most securities can be resold without registration. However, if you're covered by Rule 504, 505, and 506, you have to comply with Rule 144. And Kayla, on page 821, are the rules for Rule 144. So give me what the rules are.
There has to be adequate public information about the issuer.
So general knowledge.
The person selling the securities has owned them for at least 6 months if you're subject to the reporting requirements of the 1934 Act.
Well, you're ahead of me. So general public knowledge of corporation. And there's also a 6-month requirement. So if buyer is subject to regulation to SEC, then they must hold it for at least 6 months.
Yes.
And then Sydney, if not, they must hold it for, so you must hold it for 1 year. Must hold for 1 year. And Kayla, if you violate either one of those, then before, so let me make sure I understand this. Kayla, this restricts your freedom to resell. You're not the issuing corporation. I'm restricting your freedom to resell. So if you don't comply with Rule 144, then you would have to register it yourself before you can sell it. And it seems like, Kelsey, that effectively keeps us from getting around the rule. Violations of the SEC Act. Intentional or negligent defrauding investors by misrepresentation, omitting material information, registration statement, or prospectus. There are criminal penalties, civil sanctions, defenses. One defense is the statement of omission was not material. Jody explained that to me, and then Tellini add to that. Jody?
Basically, if it's not such a big deal, like maybe there was just like a transposition in a word misspelling.
You know, I'm thinking, Tellini, that's the best explanation of material I've ever heard. It's like, no big deal. Like, for example, if you have, and we talked about this before, Jody, the example was if I transpose the address is 2502 and I put 5202. So that's a mistake, but it's not material. And a material mistake, Talini, would be one that it's material if it could affect somebody's decision. Otherwise, it's, quote, no big deal. I like that. The other defense is plaintiff knew about misrepresentation at the time of sale. Linda?
Do you want me to explain it?
Yeah.
Oh, okay. The plaintiff, when they were purchasing whatever security, they knew that the person selling it was misrepresenting it.
Yeah, okay, so I know, so we omit, David, the fact that you are a member of the board of directors, and also you're a company apart from this company. So here's the company that we're investing in, and here's your other company here, and you're the primary supplier of raw materials for the factory here. So, Sydney, should we have mentioned that? Yes, we should mention that. But Linda, if you knew about it anyway, and you invested anyway, then you would have no cause of action. Although Jody, if you did not know about it, you would. The difference is she knew about it and Jody did not. Our defendant exercised due diligence and believed statements were true. Provide an example, AJ?
So, yeah, the defendant would believe that they would have no reason to be suspicious of the sale or like what they purchased.
And man, this would come up within, if I'm trying to sue an auditor, the auditor who did the audit of the financial statements, and as long as you did your due diligence under statement of auditing standards, and you exercise the minimum care and so forth, then you would use the due diligence defense. AJ, you think we'll come back to this when we talk about accountant's legal liability? Yes. She answered it affirmative. See, the Linwood versus Blackstone on page 822. Kayla, tell me what the facts are.
Blackstone is getting ready for its IPO. They filed a registration statement with the SEC, and at the time, their investments are suffering losses.
So we have various divisions. Division 1, Division 2, Division 3, and they're all, and one of them is losing money. And we do not disclose that because we, the issuing company and corporation, believe that the profits from Division 2 and Division 3 will make up for the losses of 1, therefore it's not material, therefore we don't disclose. Anything to add to that, Candace?
No.
Let the record reflect that that's a hearty endorsement of Kayla's description. That was, wasn't it? Very good. Now, what did the court decide and why? Megan, the trial court ruled for the company, and then what did the second, and said there's no violation here, and then what did the Second Circuit do?
They vacated the lower court's decision and they said that the plaintiff provided sufficient allegations that Blackstone had admitted the material information when they filed.
So Alex, the basic issue here is, was this material or not?
Right.
And the court decided,
The second court decided it
well,
was.
and let me talk about that. What does it mean, Megan, to vacate?
They didn't provide it, they kind of negated
To
it.
undo, to negate, that's a good term. So they negated what the lower court did, but they didn't actually say that there was a violation. What they did was, they remanded it, which means to remand means to send back.
Yeah.
So they vacated the lower court decision and remanded it with instructions to hear the case again, but now here's the correct rule of law to use. So basically the rule of law that they gave them, Alex, was a better definition of materiality. And basically said the trial court tried again, but then,
With this new definition.
and Kelsey, what do you think happened?
It ended up being material.
Well, actually, they settled out of court. Why do you think they did that? And they did not, and if you settle out of court, you can have a non-disclosure agreement and protect your reputation. Criminal penalties, fine up to $10,000 and or imprisonment for up to 5 years. Anyone who willfully violates any provision of the Act of the rules of the SEC makes an untrue statement. Candace, are they serious about this stuff? Sydney, should they be serious? And Sydney, if they were not serious and we could not depend on financial statements, then what would happen to our economy? The total chaos, the wild, wild west. Civil liabilities, any investor can sue in civil court for fraud caused by misleading or missing information. The plaintiff was not proved reliance only that she was insured. We will talk about accountants' legal liabilities again next week. And then on Friday, we'll talk about the SEC Act of 1934. And Candace, in 1933 Act is primarily concerned with the initial registration, and the 34 Act is concerned with things like insider trading. By the way, you know that Martha Stewart went to jail for what? Somebody know? That insider trading. She went to jail for lying about it. So she went to jail for obstruction of justice. And what happened, Candace, is she got a stock tip that a pharmaceutical company was going to, the FDA was going to come out with an adverse ruling on one of the drugs. Therefore, she sold the stock before the news hit, and she saved $600. She saved, and she went to jail, and then she lied about it, and then she went to jail for 3 months for $600, which to her would be like a penny to Lenny, or maybe 2 pennies. So no class on Wednesday. Michelle, you got that? And Friday we'll be back to talk about the 35. Okay, remind me.